Good evening, chat. It is a big day today. Hi, Bubba. Mwah. It's a big day today, chat. Let me tell you what. We were going to cover the TPS, the kicking out all the Haitians and Somalis case today in front of the Supreme Court. But your boy, Samuel Alito and your other boy, your boy Clarence Thomas. Holy shit, did they run wild in the streets tonight, chat. They are just straight up wildin', as the kids say. So here we go. We are going to cover that tonight. This is like an actual bombshell. You know, this is huge. Like, this is huge. It's huge. But we are going to get into that. So, guys, welcome to the show. My name is Sean, also known as Potentially Criminal. I'm an attorney in the Cleveland, Ohio area. And with me tonight is the lovely Clyde. And yeah, we're going to talk about the Supreme Court just getting down. Oh, man. On the case we talked about previously, Louisiana v. Callais. And, woo! Wow, it's bigly. It's bigly. My Negger says, can I vote anymore? No, sadly, you can't. This is huge. I mean, this guy's like, I don't think you guys get it. Like, this is le massive. I mean, this is brutal as things are considered. I don't know how else to describe it to you, chat. It is massive, and we are going to cover it. And thankfully, we're not talking about the recording, so Jeremy can't try to cuck this stream like he did my model stream and also like he did Bean Copium stream last night. So good job on that one, Jeremy. That was really the pro gamer move there. Can't see how that's going to keep lasting forever. You can't stop everybody coming after you, homie. You can't stop everybody coming after you. And hold on, chat. I need to fix one thing here. My light's a little bright in my face. I need to fix this. And we're not going to be a fag and put on sunglasses because eyes hurt too much. Like, you don't have to have the light staring at you in the face. You guys have seen my studio setup. You just put some cardboard on a fucking lamp cover and Bob's your uncle. Yes, babe, they took down Meme. Get the sleeve, ma. Yes. He cut the mall stream. It got cited for being age inappropriate. So yes, that 100% happened. Yes, Iman Rezi. Yes, Clyde TND Martin. Yes, he is. Oh yeah. That is right now. Yeah. Oh. So, Kate says, I think Sean's going to be in Brevard County. We've got Sheriff Ivy here. I am not going to be in Brevard County. I'm going to leave it at that. Eventually, you'll figure it out, chat. But welcome, everybody. Letting a couple minutes to get people in here because, yeah, guys, this is massive. This was huge today. And this all goes back to the case we covered the oral arguments for, Louisiana v. Callais. And it's all about the Voting Rights Act. And, guys, remember, Section 2 of the Voting Rights Act allows for majority-minority voting districts. This is primarily a thing in the South, though, where we needed to have districts in the South to allow black vote to actually be effectuated. And kind of take care of it that way. And hold on, chat. I'm trying to fix something here. Okay. Well, there we go. I don't know if that's going to change too much here, but ultimately, and we go to what happened here, and we're going to start with a little bit of the back trend on this. And ultimately, these have ensured that we end up with districts where you have majority and minority. And that has caused, in the South, that creates all kinds of problems. And you guys, we've talked about this before. that has led to all kinds of things to go on with lawsuits anytime there's gerrymandering. Throughout history, especially in the left, they'd run around screaming, well, this is all racism, help us. And they would be able to say racism. And from there, the courts would reject any gerrymanderings if they thought it was affecting the ability of minorities, primarily, i.e. black folks, from being able to exercise their votes. So what did that do for us? Well, that put us in a unique situation. And currently, that situation is this throughout the South. And it's this right here. This is the current map of the South as of right now. These are all there are other Voting Rights Act cases, other places. But in the South, there are about 24 seats at stake, 24 congressional districts. And if you notice, in a lot of these places, it's in kind of, urban areas and urban districts. And then you get some of these goofy ones, or you get like half of Mississippi. And then the big one in question is here in Louisiana. And this is where we come from things. In Louisiana, they passed a redistricting and a gerrymander where these are the two districts that are majority minority. This was passed at a time when the black, caucuses and all of them wanted to push for this. This was their way of, look how ridiculous this one congressional district is. Look how ridiculous it is. It starts all the way down here in Baton Rouge, and it goes all the way up to Shreveport, Louisiana. Look at how ridiculous that one is. Look at how ridiculous that is. Absolutely nonsense. Absolutely nonsense. Absolute nonsense. But basically, you have this black belt, and they basically designed a political plantation for black folks. Because remember, the Democrats treat the blacks as voting cattle. And that they are little good black folk and they'll do as Massa says. Because, the Democrats are racist fucking scumbags. So we are now left with this. And it was taken to court. And we went up through the Fifth Circuit. The Fifth Circuit's like, yeah, you can't do this. And ultimately, the Supreme Court had to get involved. And kind of like with these trans cases, the participants involved thought, oh, the Supreme Court will agree with us. We need certiorari. And it's like, do you really think that's a good idea? Do you really think that's a good idea? Hold on, chat. All right. Sorry, I had to put that all together. Because they want you to do the right things here. Hold on, chat. This is... There we go. This is going to be big. I'm hacking the planet. Yes, I am. Meme copium. Yes. Ma, get the sleeve. Jeremy took down code COPE on the Dragon's Treasure. Yes, chat. You can use code COPE, or you can be a true king or queen and use the promo code criminal at the Dragon's Treasure. Get you 10% off your coffee, your tea, and your soaps. That's right, chat. Only at thedragonstreasure.com. You can still use the code JUBUL to get 15%, but, I don't know if you guys would want to be using the bull to help you save money. That seems like you're cucking your wallet at that point. No, let that credit card get its workout in. Let that credit card get its workout in. And we go from there. Epic Fantasy says, anime sucks, Cope and Sneed. Yes. Make You Law Simple says, GOTUS. I like that. Yes. Stabby says, how many states are going to act on this? I want to know. Well, we're going to get to that. So let's get back to where we were, guys. That was a big detour. I am so sorry. It is time to go, but this is how retarded the districting got. So there was a lawsuit for this. After multiple lawsuits, a group of non-black voters challenged, claiming they are being forced to draw majority black districts. And that they're basically saying, well, wait, this is based on race, which means it's racism, and racism is not allowed under the 14th Amendment. After all, we have equal protection under the law. And ultimately, the Fifth Circuit agreed, and we got to here. Now, remember, this is interesting because we're going to see some arguments from people, but we covered earlier this year Ketanji Brown Jackson in the 9-0 Supreme Court when they talked about employment discrimination. And these circuit courts had created on their own this idea of the law that if you were a white person, you were a majority, you were in the majority, you were in a racial majority, and you were being discriminated against by minorities, you had to prove extra steps under employment discrimination under the law in Title VII. I remember what Ketanji Brown Jackson said. Discrimination is bad. We don't make white people prove more things than black people. Everybody has the same rules. Sounds pretty reasonable, but apparently not so much as we get to here, because holy cow. Yeah, let's get to it, chat. Let's get to it. Enough foreplay. It's time. It's time, chat. Get the sleeve, Ma. Get the sleeve, chat. Here it is. Certified Hood Classic. Louisiana v. Callais et al. Here we go, chat. Yes, criminal, only the savings you'll get in the Dragon's Treasure. But here we go, chat. Here we go, guys. Certified Hood single. Coming in, dropping the bars. And ultimately, we're going to go through this. And we'll just click to the holding here. And we'll start from there. Well, you know what? Actually, we'll just start here. We'll get through the syllabus. We're not going to read the syllabus. I don't want to spoil it for you. But here we go. Here we go, chat. Alito delivered the opinion in the court. You know, as much as I talk shit about Machine Gun Sammy, oh, buddy, he delivered today. He took two guns. It's like Dr. Dre, started talking about, just took those two guns. He spun them on his fingers. He kicked them swinging doors in, and he started gunslinging. When he hears somebody singing, it sounded like it's a G thing in reverse. So he kept the motherfucking heads ringing. He did. And you know what happened? Who joined him? Roberts joined. Thomas, your boy Clarence, your boy Neil, your boy Brett, even though he's a puss most of the time. And even Amy Barrett joined us. Thomas and Gorsuch filed, their own concurrence. And then guess what? You have Kagan, Sotomayor, and Judge Jackson opposing. So, chat, this was a resounding victory. 6-3. Here we go. Alito delivering the opinion. And he starts off with straight fire. Section 2 of the Voting Rights Act was designed to enforce the Constitution, chat, not collide with it. Whoa. God, I love this, man. I love this writing. Just get your hair tingling. Unfortunately, lower courts have sometimes applied the court's Section 2 precedents in a way that forces states to engage in the very race-based discrimination the Constitution forbids. Remember, Chad, anytime somebody gets really mad, just look at him and say, I'm sorry that we enforce the 14th Amendment in this house. I'm sorry that we have equal protection under the law. I'm sorry that black people don't get special rights. The tension came to a head when Louisiana redrew its congressional districts after the 2020 census. In 2022, a federal judge in the Middle District of Louisiana held that the map adopted by the state likely violated Section 2 because it did not include an additional majority black district. They tried to get rid of one of them. And they got rid of the one snaking up the state. When the state drew a new map that contained such a district, its new map was challenged as a racial gerrymander. A 3-judge court in the Western District held the new map violated the Equal Protection Clause. Based. And the state appealed this. So you might be saying, wait, what? This was all by design, chat. The Democrats got baited into doing this. They got baited into doing this. And Louisiana's like, oh, I guess we're going to have to appeal. You can't destroy our map, judges. No, we want it. We have to do this. Wink, 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 wink. So, yeah, you motherfuckers got played out there. You got played. Baited down in the swamp like a gator. Yup. Or as they say in Louisiana, the Democrats were a bunch of couillons, foolish people. I believe that's how you pronounce it. The parties originally briefed and argued this suit last term, and they did. And their arguments at that time highlighted the problems in the existing body of Section 2 case law. One problem resulted from the rule in racial gerrymandering cases that says that, like other cases involving claims of racial discrimination, strict scrutiny is triggered only if the race predominated in the state's decision-making process. In this suit, Louisiana adapted the map and created the majority black district because it quite reasonably anticipated that if it did not do so, the Middle District would order the use of the map. With a differently configured second majority district that would effectively oust an incumbent whom the legislature sought to protect. And here's the issue. Under existing case law, that situation posed a question whether race or politics was the state's predominant motivation. So here we go. Oh, Thumbuggy says, not bad. Yes. Well, thank you. I tried to do my Cajun a little bit. Another problem stemmed from the long-resolved question whether compliance with the Voting Rights Act provides a compelling reason that may justify the intentional use of race in drawing legislative districts. For over 30 years, we have assumed for the sake of argument that the answer is yes. And they're pointing out, wait, we can't be enforcing racism. And we have gone further and assumed that it's enough if a state has a strong basis in evidence for thinking the Voting Rights Act requires race-based conduct. But allowing race to play any part in governmental decision-making represents a departure from the constitutional rule that applies in almost every other context. Oh, chat. Yes, remember, it's racism. I thought racism was bad, but apparently not. Also, chat, you may start hearing it's 8:30. 2.0 will start doing the dulcet tones of the casino pregame here, in case you hear it. Shout out Keys. Songs in the Key is CWC. 2.0 loves your shit. She sings it almost all the time. These and other problems have convinced us that the time had come to resolve whether compliance with the Voting Rights Act can indeed provide a compelling reason for race-based districting. We now answer that question. Compliance with 2 as properly construed can provide such a reason. Correctly understood, Section 2 does not impose liability at odds with the Constitution, and it should not have imposed liability on Louisiana for its map. Compliance with Section 2 thus could justify the state's use of race-based redistricting here. The state's attempt to satisfy the Middle District ruling, although understandable, was an unconstitutional racial gerrymander. And we therefore affirm the decision below. And it says, ratify in 1870 the 15th Amendment, chat. Yes, there was a 13th, and then we gave them 2 more. Provides the right of the citizens of the United States to vote shall not be denied or abridged by the U.S. or any state on account of race, color, or previous condition of servitude, meaning slavery. For many years after, states heavily suppressed the right of black citizens to vote, which they did. Yes, they did the shit out of it. States employed a variety of notorious methods, including poll taxes, literacy tests, property qualifications, white primaries, and grandfather clauses in a blatant effort to suppress black voting. Even as late as the mid-1960s, black registration and voting rates in some states were appallingly low. They very much were. In addition, states employed legislative districting schemes to prevent the election of black candidates and candidates that black voters preferred. Section 2 of the 15th Amendment authorizes Congress to enact appropriate legislation to enforce the protections, and in 1965 invoked that power to enact the VRA. And they talk about the act and its amendments in the 70s forbade some of the practices that have been used to suppress black voting, including literacy tests and poll taxes. And they go on through here and they talk about what these are. We have held up many of these provisions in Katzenbach, and that's a case back here, chat, where they do quite a few things, and it's South Carolina v. Katzenbach. This is a pretty big case as far as what's going on and what they could fight. We're not going to read it, but it is actually, if you want to learn some stuff, it's really good. It's really, really good. Section 2 of the VRA in its original form closely tracked the language of the amendment it was adopted to enforce. At the time, Section 2 simply stated, no voting qualifications or prerequisite to voting or standard practice or procedure shall be imposed or applied by any state or political subdivision to deny or abridge the right of any citizen in the United States to vote on account of race or color. Okay, that's pretty straightforward, right? That's pretty straightforward. In Mobile v. Bolden, the court interpreted this language, and 4 justices concluded in a plurality opinion that facially neutral voting practices violate Section 2 only if motivated by a discriminatory purpose. Justice Stevens, who concurred in the judgment, proposed a different but similarly demanding standard. And they say, indeed, in his view, a districting practice, even if motivated in part by race, would not violate Section 2 as long as it's supported by valid and articulable justifications. You're like, okay, I like this. I like this so far. I like this. David says, Sean, you should. What? What should I do? What should I do? Oh, go through it. We're not going through South Carolina v. Katzenbach. I've read it before. And they say, Bolden aroused an avalanche of criticism both in the media and within the civil rights communities. Yes, because it was so racist. Members of Congress evidently shared these concerns, and in 1982, shortly after Bolden, once again, normally one of the things Congress can do, they can abrogate that decision by amending Section 2. The House bill was originally passed under a loose understanding that Section 2 would prohibit all discriminatory efforts of voting practices, and that intent would be irrelevant. But this version met stiff resistance in the Senate. Thank God it did. Thank God it did. The House and the Senate eventually compromised, and the final product included both an effects test in Section 2A and a robust disclaimer against proportionality in Section 2B. I should change my format to avatars only, no new content, just talk about old news, which is sprinkled in between long ad reads and grifting for super chats. I can do a lot of AI songs too. Would that be a good thing too, David? We just do all AI content. Oh, but yes, that would be perfect. That would be perfect. They say this later provision also specifies what a plaintiff must establish to prove a Section 2 violation. The provision requires consideration of the totality of the circumstances in each case. It demands proof the political process leading to a nomination or election in the state or political subdivision are not equally open to participation by members of a protected class, in that its members have less opportunity than other members of the electorate to participate in the political process and to elect representatives of their choice. Congress took this language almost verbatim from Justice White's opinion in the court in White v. Register, 1973, and which involved a vote dilution issue, a claim that districting impermissibly lessened the weight of the votes of minority voters. And they say in White, the court affirmed that Texas had used a 2 multi-member electoral districts individually to cancel out or minimize the voting strength of racial groups. They say vote dilution, a vote dilution plaintiff had to show the political process leading to nomination and election were not open to participation by the group in question. Well, I guess, are they going to argue that the Democrats aren't allowing black folk to run? That'd be interesting. That would be very interesting. and that its members had less opportunity than other residents to participate. The decision in White did not say anything one way or another about proof of discriminatory purpose or intent. But the rationale rested on evidence that gave rise to an obvious inference the state had set out to prevent: the election of candidates preferred by minority voters. The Texas redistricting scheme generally used single-member districts, but employed multi-member districts in new parts of the state where single-member districts might have resulted in the election of minority candidates. And the court says the use of multi-member districts is not necessarily or per se unconstitutional, but it recognized that such districts can be employed to achieve discriminatory ends. The court also cited strong evidence the legislature had done so in the case at hand. They wrote that when the Democratic Party was dominant in much of Texas, the court had noted that a white-dominated organization which had effective control over candidate slating within that party had engaged in racial campaign tactics in white precincts to defeat candidates who had the overwhelming support of the black community, thereby effectively excluding the black community from participating in the Democratic primary selection process. Oh, wow, the Democrats were racist. Who knew? Who knew? The court likewise cited that the legislature had invidiously excluded the Mexican Americans from effective participation in political life. I think, specifically in the election of representatives to the Texas House of Representatives. And they said this presented a situation which circumstantial evidence suggested very strongly the state had created multi-member districts for the purpose of diluting minority votes. So ultimately, when they were talking about how to modify Section 2 of the VRA, the report from the Senate Judiciary Committee explained the amendment's purposes was to repudiate Bolden and establish a new voting dilution test based on white. Who white? This court first construed the amended version of Section 2 in Thornburg v. Gingles, or Gingles, I think. Gingles concerned a challenge to North Carolina's multi-member districting scheme on the ground that it diluted the vote of black citizens. Gingles was decided at a time when this court had often paid insufficient attention to the language of statutory provisions. Notice he's saying, what is he saying? Well, Alito is echoing Nick Rekieta. They didn't read the statute. They didn't read the statute, chat. They didn't read the statute. No. They didn't read the statute. Instead of analyzing what the statute said, the opinion simply quoted the text of amended Section 2 and then jumped to the right to the Senate Judiciary report. It said, relying heavily on that report, the opinion set out 3 threshold requirements for proving a vote dilution claim, plus a non-exhaustive list of factors to be considered in making a final decision. So to succeed in proving a Section 2 violation, Gingles taught you must make 4 showings. First, you must show the minority group in question is sufficiently large and geographically compact to constitute a majority in a reasonably configured district. I don't see how that works here. Okay. They say a district is configured, we explained, if it comports with traditional districting criteria, such as being contiguous and reasonably compact. And they say, second, the minority group must be able to show that it is politically cohesive. Third, well, they're going to say, yes, so we all do what the mass of Democrats tells us to do. Yes, sir, because we simple black folk on the plantation. And they say, third, the minority must be able to demonstrate that the white majority votes sufficiently as a bloc to enable it to defeat the minority's preferred candidate. And it says, finally, and fourth, a plaintiff who demonstrates the 3 preconditions must also show, based on the totality of the circumstances, that the political process is not equally open to minority voters, which, well, that doesn't exist anymore. So you can vote all you want. In fact, minorities get to vote multiple times. And they can't afford IDs, so we don't even make them get IDs. And real quick, we got to address this real quick. Coffee Cat gifting 5 subs. And even though he couldn't do it for us earlier, chat, we get a no woo. Thank you for your support, your generosity. Thank you so much. Thank you. Fair Frozen 55 for $5 says Sean doesn't have to put up with the grays anymore. It's the law. That's right, chat. That's right. You see this? This is green. That means not welcome. Oh. Well, let's keep going here. In later cases, redistricting plans that states created to comply with the VRA were themselves challenged as racial gerrymanders. This court approached such cases by building on the framework of discrimination cases in the Equal Protection Clause. In those cases, if race played a role, made the government actor strict scrutiny applies because now the government's involved in racial decisions. And, well, we don't like that. We don't like that. That's kind of a problem. It's kind of a problem, isn't it, chat? And they say under this standard, the government need to assert a compelling interest that justified its use of race. And if the analysis progressed beyond this point, the government had to show its use of race was narrowly tailored to vindicate that interest. The court modified this framework for racial gerrymandering cases. And it says, although any use of race in government decisions generally triggers strict scrutiny, in gerrymandering cases, the challenger must show that race was the government's predominant consideration. That's Bush v. Vera. And in cases where race predominated, and this is Bush as Bush, the governor of Florida, where race predominated, states would sometimes assert compliance with the VRA provided a compelling interest in satisfying the use of race. Yet we never decided whether compliance with the act could constitute a compelling interest. And that's the thing here. Are we allowed to be racist to comply with the law? So instead, we repeatedly assumed without deciding that the VRA could constitute a compelling interest because in all those cases, the act actually did not demand the state's race predominant districting. Thus, the states in those cases could satisfy strict scrutiny regardless. Which you're like, wait, that means you're allowing them to be racist to cure racism, which you're like, but wait, I thought we weren't allowed to be racist. You're like, court's like, what do you want me to do about it? Court's like, go fuck yourself. You're like, wait, how's that fair? How's that fair? It just doesn't work. It doesn't work. It's very weird how it's done, isn't it, Chad? It's very weird how it's done. Let's see here. Hold on, chat. Oh crap, what was I looking for? Oh shoot. Oh crap, hold on here, chat. Let's see here. Okay. Sorry, I had to grab a couple of things here in chat. Sorry. All right. I grabbed some wrong stuff there. I feel like I clicked on a quartering video. Sorry. So ultimately, the first case the court explicitly made this assumption was in Miller v. Johnson. It concerned a majority black district that was designed to satisfy the Justice Department's plea clearance demands under Section 5 of the Voting Rights Act. Remember, there were times the Department of Justice had to work with states and they had to go through the DOJ to pre-clear districting. Because believe it or not, black people were being denied the right to vote on, like, Mississippi burning is kind of like, was a thing. Obviously, that got a little hyped up, but it was really bad down there. People were getting killed. Democrats couldn't let the black folk vote. And they said the Miller court first found the legislature had subordinated traditional race-neutral principles, including, not being bound to compactness, contiguity meaning all in one piece, and respect for political subdivisions. And they say, for this reason, the court that race had predominated the creation of the new district, and the state had to demonstrate that it was narrowly tailored to achieve a compelling interest. The court declined to address whether, in some cases, compliance with the VRA could provide a compelling interest independent of any others in remedying past discrimination. Now, they go on to talk about a couple different other cases here. They talk about Shaw v. Hunt. That's another big voting case. There was also, it was also known as Shaw too. They applied strict scrutiny to a redistricting plan the state had crafted to comply with both Section 2 and 5 of the VRA. And once again, they left open that question of, is the VRA, could itself provide a compelling interest to justify racial gerrymandering? There was no discussion of it. They talk about other cases in the Alabama Legislative Black Caucus versus Alabama, sir. We applied strict scrutiny to a race-predominant districting plan the state had created for two purposes. First, to come close to a one-person, one-vote ideal, and to ensure compliance with Section 5 of the VRA. We held that even if the Voting Rights Act could provide the interest, the map did not satisfy strict scrutiny because it was not required by the Act. Once again, we left open whether compliance with the Act remained a compelling interest. They talk about, and then Alito goes back. We continued our long-standing assumption complying with the VRA is a compelling interest. They point out, well, was it really? And they go through this and they say this legal framework was all in place when the lawsuits involving Louisiana's districts were filed and litigated. And they say, as noted earlier, the underlying legislation in the suit resulted from Louisiana's response to population changes by the 2020 census. Also, the Republicans dominating the House and the Louisiana government. The subsequent reapportionment of House seats among the states left Louisiana with the same number of seats, 6, that had previously been allocated. But due to shifts in population, the state needed to recalibrate its districts. And this is the 2020. This is the map from 2013 to 2022. And notice this kind of makes some sense. Okay. In 2022, Louisiana enacted a new map that closely resembled its immediate predecessor. And notice that it kind of does a similar thing here. And like its predecessor, included only one district in which black voters were a majority of the voting population. In the above maps, it is the bat-shaped District 2, which includes much of New Orleans. As soon as HB 1 was enacted, lawsuits were filed, asserting that the map violated the VRA by packing a large number of black voters into a single congressional district and cracking the remaining black voters among the other 5 districts. And that is a term, chat, that in election law, they would talk about it. You're cracking. You're going to be a creepy-ass cracker. You're cracking the black vote. That strong black rock. And those white waves just crack it open. Cracking like the walls of Jericho. Got my black preacher voice going there. When the suit was filed, the Robinson court issued a lengthy opinion concluding that HB 1 likely violated the VRA by failing to include a second majority black district. The court thus entered an injunction requiring Louisiana to implement a new map before the 2022 election, which was less than 6 months away. We're going to get to this part here because there's a very interesting thing that's going to happen by tomorrow. Uh-oh. Louisiana objected to the decision and promptly appealed. But because of circumstances outside the control, its appeal ended up in limbo. It's where unbaptized babies go, too. It used to be where the Catholic Church thought they went. This court granted certiorari before judgment and held the case pending a decision in Allen. Nearly a year later, after deciding Allen, the court dismissed the petition as improvidently granted and remanded back to the Fifth Circuit to consider Louisiana's appeal in the ordinary course. Because by that time, the 2022 election had passed, and the urgency that had justified the injunction was no longer present. In a tentatively worded opinion, the Fifth Circuit held that Robinson's district court decision was valid when it was issued, but that the injunction was no longer needed. In the absence of urgency, The Fifth Circuit remanded the case to the district court with instructions to give Louisiana time to draw a new map. If they fail to do so, the district court could proceed with a trial on the merits and, if needed, remedial proceedings, meaning ultimately, the court would end up drawing it for them. So Missouri Battle Flag says, you know anything about Catholics? I do. That was literally part of Catholic theology until the 90s, where they officially said God actually gives them mercy, in that by granting mercy and their salvation and the, giving them that mercy and grace that they would be saved. So yes. Yes, limbo was never a doctrine, a speculation from the theologians. Yes, but it was something that many Catholics believed in. So I'm not making shit up, chat. Like just écoutez les enfants. Sometimes Poppy is going to drop knowledge on you, and it's going to be okay if you don't want to hear it. You're going to be okay if you don't want to hear it. So it's just rough like that. So I get it. I get it sometimes. After the Fifth Circuit's remand, Louisiana did not have many options. In the Robinson decision, the district court held the plaintiffs were likely to prevail on their claim the VRA demanded the creation of a second majority district. So if Louisiana refused to adopt the map, the district court would likely draw one and mandate its use, which does happen. Wishing to avoid that outcome, Louisiana decided to draw on its own map. After a deliberate process, Louisiana enacted the map at issue in this suit, which is this hammered dog shit of this. This is that monstrosity. SB 8 retains the original majority-minority district, then it adds an additional majority-minority district. District 6 connects black population from Baton Rouge and Lafayette with the black population at Shreveport. And yes, this is illustrative plan 1. Illustrative plan 2. I love how they're like, we have water areas. Like, do people not realize there are fucking water in, is it that confusing? Is it that confusing here? Is it really that confusing? But it's very funny how they do this. The illustrative maps here. These maps also include a second majority-minority district, but one with different boundaries, shown in blue in the top 4 maps. And this is how you get that majority-minority right here. And green in the bottom 2 maps. So notice how they're doing it kind of like they're splitting Louisiana in half. The district connects largely urban communities of Baton Rouge and Lafayette with the rural black communities in the northeast corner of the state. By contrast, District 6 in the current thing connects them with populations in the distant black population of Shreveport. Louisiana adopted this scheme rather than the one used in the Robinson maps, because it's all part of a plan. This is all planned. Because rather than the one used, because it protects the Republican incumbents in the state considered most important. Speaker of the House Mike Johnson and House Majority Leader Steve Scalise and Appropriations Committee member Julia Letlow. You notice, chat, you're like, wow, so why didn't they do this? Well, because they were going to fuck over other candidates that were already in place, including the Speaker of the House. So guess what? This was all baited. The fucking Democrats got baited. And now they fucked themselves. They got fucking greedy. They wanted all these black districts, and now they're going to lose them all. Just brilliant work. Brilliant work out there. Brilliant work out there by the Democrats. Not long after the law was enacted, another lawsuit was filed in western Louisiana. A group of plaintiffs asserted that was a racial gerrymander that violated the Equal Protection Clause. Plaintiffs intervened in the litigation, seeking to defend Louisiana's decision to draw a second majority district. Because the Callais plaintiffs challenged the constitutionality of the apportionment, a district court of 3 judges was convened to hear the suit. Court held a 3-day hearing, which was consolidated with a trial on the merits, which you can do at times. So here we go. Whatever happens, I hope Hank Johnson loses his seat. Well, don't worry. We're going to go through some maps. Observing SB 8's second majority minority district stretches some 250 miles, chat. 250 miles. And when I was a kid, I lived in Marcy Captors District when I lived in Lorain County, Ohio, on the west side of Cleveland. And then I moved to Bowling Green for college. I wasn't in our district for 4 years. And then I moved to Toledo for law school. So from the time I was a kid, you know, like I applied to West Point in Marcy Captors District. I moved 100 miles away. And years later, and she was still my fucking congresswoman. But yes, these are so shitty things to deal with. They say in the Northeast, Louisiana is slicing through the predominantly metropolitan areas to scoop up pockets of predominantly black populations from Shreveport, Alexandria, Lafayette, and Baton Rouge. The court concluded the map affected a racial gerrymander that violates the Equal Protection Clause. And that's Callais v. Landry, because Landry is the governor. Yes. Yeah. 112 Toledo. She is a dinosaur. Yes, she is. It's amazing to think there's a time where someone's thin enough to go to West Point. Yeah, there was. I got waitlisted, and then I fucked my knee up, and that didn't make it any better. So they're like, hey, we want you to redo your test. Where you have to do the basketball throw and the shuttle run. And I'm like, I kind of tore my MCL. And they're like, oh, well, you're going to have to let it ride. Sorry, bro. Did not work out, obviously. Yeah, waitlisted. Har. No, like waitlisted. And by the like when they compiled everything based on my grades and everything I had done, I was like 100 people would have to die before I would be in line to get in there. So imagine the Sean we would have if we went to West Point. He'd probably have me fucking like wiping a village off the map somewhere. Louisiana Robinson interveners appealed the decision directly to the court. The court noted probable jurisdiction. After an initial round of briefing and argument last term, the court restored these cases to the calendar for re-argument this term. We argued supplemental briefing on the following question: whether the state's intentional creation of the majority-minority district violates the 14th or 15th Amendments. And they go on that our question, they say, because the state's intentional creation of a majority-minority district had been prompted by an order suggesting that such a district is required, our question necessarily implicated the correctness of our long-standing assumption that compliance with the VRA may justify what the Constitution generally condemns: the use of race as a basis for government action. Notice, every time, and this is the court doing it the right way. This is the court doing it the right way. We're not going to address the issue until you bring it to us. But hey, this every time they're like, wow, this is a really good question. Nobody's asked it. Maybe one day. And since 1965, it was never answered until today. 60 years later. It's like, well, yeah. They say the question was pending in several lower court cases, but in light of the potential impact on these cases on upcoming elections, we concluded that resolution of the question in this suit was appropriate. So in considering whether the Constitution permits the use of race to comply with the VRA, we start with the general rule: the Constitution almost never permits the federal government or a state to discriminate on the basis of race. Such discrimination triggers strict scrutiny, and our precedents has identified only two compelling interests that can satisfy that standard. One compelling interest not relevant here is avoiding imminent and serious risk to human safety in prisons, such as a race riot. That is like one of the only times you can keep races apart. So, yes, that is a thing, chat. That is a thing. The only other compelling interest we found is remediating specific identified instances of past discrimination that violated the Constitution or a statute. It says the rise to the level of a compelling state interest, an effort to remediate past discrimination must satisfy two conditions. First, the discrimination must be identified. Discrimination. In other words, a state or government must identify the instances of past discrimination that it aims to remediate, and in light of that, must determine the precise scope of the injury it seeks to remedy. The states and the federal government have no compelling interest in generally remediating past discrimination in a particular industry or region, or the effects of societal discrimination. And it says, after identifying the specific discrimination, the institution that makes the racial distinction must have a strong basis in evidence to conclude its action is necessary. Uh-oh. And they say our acceptance of race-based state action has been rare for a reason. Distinctions between citizens solely because of their ancestry are by their very nature odious to a free people, whose institutions are founded upon the doctrine of equality. And in redistricting, where a state assumes a group of voters race that assumes that from a group of voters race that they think alike, share the same political interest, and will prefer the same candidates at the polls, it engages in racial stereotyping at odds with equal protection. Oh, well, they're black. They want to vote for the Democrats, massa. Apparently, you're not allowed to think that. The question before us is whether compliance with the VRA should be added to our very short list. To answer that question, we must understand exactly what Section 2 of the VRA demands with respect to drawing legislative districts. And they talk about Section 2 here, as amended. And we're not really worried about this no qualification or prerequisite to voting shall be done. We're like, there's no issue with that here. Now we get to Part B. A violation is established if, based on the totality of circumstances, it's shown the process is leading to the nomination or election and the subdivision are not equally open to participation by members of a class of citizens protected. And they say to the protected by subsection A, and its members have less opportunities than other members of the electorate. The extent to which members of a protected class have been elected to office in state or political subdivision is one circumstance which may be considered. Provided nothing in this section establishes a right to have members of a protected class elected in numbers equal to the proportion of the population. So if you have a 40% black community, you are not entitled to having 40% black congressmen. That's not how this works. Although in reality, when you look at the number of minority congressmen in Congress, they far outgo the proportionality overall across all 435. And also, guys, 372 people here, guys. If you guys could hit like, get me over that, as I learned from Copium, that 200 number. And then YouTube will have to promote us. And we'll get more people. Maybe we'll get a bunch of commies who'll come in here and cry and suffer. So help me out, chat. Help me out. And they say, this is not the easiest language to parse, and we will therefore break it down in steps. So he's going to explain to us like we're 5, chat, which is helpful because I am retarded. Presumably some of you are as well, being a Tylenol American. Begin with subsection A. We take as a given that a legislative redistricting map may constitute a standard practice or procedure. If that were not so, there'd be no statutory basis for any of our vote dilution cases. Notice 1994, Clarence Thomas. Remember, guys, he's been around forever. They say, therefore, subsection A means that a districting map may run afoul of section 2 if it results in denial or abridgment of the right to vote on account of race or color. So we already got it. Section A. We know we're there. Something happened. Therefore, we have to decide what it's about. Section B explains if such denial occurs, the political process of the nomination or election are not equally open to participation by members of racial groups, in that they have less opportunity than other members of the electorate to elect representatives of their choice. And they say, forever, ever? Well, actually, no, more like in Hamilton. Forever and ever and ever and ever. Oh. They say in this complicated verbal formulation, the key concept for present purposes is less opportunity than other members of the electorate to elect representatives of their choice. This language sets the baseline of to assess the opportunity of minority voters. The opportunity that other members of the electorate have to elect their preferred candidates. To understand this baseline, we must nail down the meaning of three terms: less opportunity, other members of the electorate, and elect. This is statutory interpretation, chat. We're doing a Nick Ricada. We're reading the statute. In isolation, opportunity could refer to either a desired outcome or a chance to achieve that outcome. As used in Section 2B, however, opportunity must mean a chance. Just give us a chance to achieve a desired result. Because the VRA does not guarantee equal outcomes. God almighty, give it 20 years. We're probably going to hear that. That's actually an issue. Man, Marcia says that's what Hamilton sounds like. I'm glad I never saw it. No, like there's some songs in it that are pretty good. Like all the ones with King George in it are pretty good. The rest of Hamilton's pretty gay. No, and then the Hamilton. Like, fuck that. So, accordingly, less opportunity must mean a lesser chance. In ordinary usage, less opportunity often takes on such meaning. One might say, for example, men under 6 feet tall have less opportunity to play in the NBA than those who stand at 6'7", the current median. That's right, Chad, as short kings. The next term, other members of the electorate, specifies the comparator to be used in determining whether the group protected by A has suffered or is threatened with suffering less opportunity to elect representatives of their choice. In conceptualizing the members of this comparator group, we may think of a randomly selected member of the electorate who has particular voting preferences, or who may think randomly selected a group of voters who share certain voting preferences. These preferences may be based on a candidate's party affiliation, ideology, stance on a particular issue, personal charisma, or some other characteristics. But whatever they are, the situation of these randomly selected voters must be compared with that of minority voters alleged to have suffered vote dilution. This brings us to the final term, to elect. As used here, this term means achievement of electoral victory by casting a ballot. Putting all these terms together, the baseline is the chance enjoyed by non-minority voters to ensure the election of their preferred candidates. Wow, isn't that pretty interesting how he broke that down for you guys? Isn't that interesting how he just broke that down like that? Wow, it's very simple. What then is the chance given that a non-minority voter group of non-minority voters has to secure the election of a preferred candidate? The answer to this question depends on the voting preferences of other voters in the district. For example, in a district where most of the voters prefer Democratic candidates, a Republican voter in that district will have a low chance of securing the election of his or her preferred candidate. But that chance would be higher if the district were instead filled with voters who preferred Republican candidates. It says the roster of voters who end up in a given district depends in turn on the districting criteria used by the state in drawing a map. If a districting map is produced by computer, as is generally the case today, depends where you're at, because no, most gerrymanders are in place for a reason. We may think of all the parameters in the algorithm that the map maker uses. One necessary parameter would be the number of districts required by law. Another would be a range of inter-district population variations that is small enough to comply with the one person, one vote requirement, chat. And that's why you can't pass, we could just make one district be 1 million black people, and then we take all the other districts and pass them around. You're not allowed to do that. It's got to be one person, one vote. It has to be generally equal in size for your district. That is something that's been around for a long time now, and that's because otherwise that's how you do it. That's how you would do it. That is the ultimate issue here about how that would happen. Let's see. What was the case? And ultimately, one person, one vote came about through the case of Baker v. Carr. That was part of the Earl Warren Court. It's one of the bigger kind of pre-Voting Rights Act, but it was a big thing because otherwise you could just do that. You want to put this opinion in music? Oh, we're getting to the good part, Marcia. We're getting to the good part. The algorithm might go on to lay and assign priorities to whatever additional permissible criteria is there. For example, the legislator might want to minimize changes in the prior map, avoid districts with discontiguous territory, which can happen sometimes if you're not paying attention, like districts get pinched off. Avoid splitting counties or municipalities. That's a very big one, drawing along county lines. It might impose a certain standard of compactness, aimed to protect some or all incumbents, which is generally a big thing. Promote the prospects of a particular political party. Yeah. Very common. When this algorithm is used, the map it produces may place a particular voter or group of voters in a district which a majority generally disagrees, or only sometimes agrees with their preferences. But in any event, the opportunity of these members of the electorate to contribute their votes to a winning cause is whatever opportunity results from the application of the state's combination of permissible criteria. That is what our randomly selected individual voter and group of voters can expect regarding their opportunity. And under Section 2, a minority voter is entitled to nothing less and nothing more. Do you have the ability to vote? Yes. Can your candidate have a chance at winning? Yes. Is it a good chance? Doesn't fucking matter. Boom, you've got it. Not only is this the best reading of the text, it also ensures that Section 2 does not exceed Congress's authority under Section 2 of the 15th Amendment. Remember the power to enforce the amendment by appropriate legislation. Thus, to lie within authority, the VRA must effectuate appropriate measures. The constitutional prohibition in Section 1 of the 15th Amendment. So they talk about, well, what do you do here? Well, our 14th and 15th Amendment jurisprudence dictate what constitutes appropriate legislation. And they say, as the court has long held, the 15th Amendment bars only state action motivated by a discriminatory purpose. So a law that seeks to enforce the 15th Amendment by prohibiting a mere disparate impact would fail to enforce a right the amendment confers. And they say that's never appropriate because Congress cannot enforce a right by changing what the right is. To say, for that reason, the focus of Section 2 must be the enforcement of the 15th Amendment's prohibition on intentional racial discrimination. When Section 2 is properly interpreted in the way we have outlined, it's officially congruent with the amendment's prohibition. While that interpretation does not demand a finding of intentional discrimination, it imposes liability only when the circumstances give rise to a strong inference that intentional discrimination occurred. Suppose, for example, the state's algorithm yields numerous maps of districts in which the members of a majority group constitute a minority constitute a majority, and suppose the state cannot provide a legitimate reason for rejecting all those maps and eliminating all majority and minority districts. In such a situation, the inference of racial motivation is strong, and the 15th Amendment permits the imposition of liability without demanding the courts engage in the enterprise of determining what happened and whether it was motivated by race. So they're saying it's very limited to do this. Only when understood this way does Section 2 of the VRA properly fit within Congress's 15th Amendment power. That's this big chat. By contrast, interpreting Section 2 to outlaw maps solely because it fails to provide sufficient numbers of majority and minority districts would create a right that the amendment does not protect. And it would run headlong into the Act's express disclaimer against racial proportionality. So it said, properly understood, Section 2 does not intrude on states' prerogatives to draw districts based on non-racial factors. Redistricting constitutes a traditional domain of state legislative authority. The Constitution imposes some restrictions on this power, but we are otherwise free to withdraw districts they please. We have held that they may use traditional factors to do this. Nothing in the Constitution requires states to heed these criteria, of course, and the desirability of some of these criteria might be disputed. But because they are not forbidden, it is up to each state to decide what weight, if any, they warrant. The same is true with respect to drawing of districts to achieve a partisan advantage. Disapproval of partisan gerrymandering dates back to the founding. That's true. But partisan gerrymandering claims are not justiciable in federal court. Oh no, chat. Federal judges have no license to relocate political power between the two major political parties with no plausible grant of authority in the Constitution and no legal standards to limit and direct their decisions. Thus, in considering the constitutionality of a districting scheme, courts must treat partisan advantage like any other race-neutral aim, a constitutionally permissible criterion the states may rely on as desired. For this reason, hello, Chief Justice Owedo, this reason, woo. For this reason, we have repeatedly made clear when a state defends a districting scheme on the ground that it was drawn for partisan purposes, plaintiffs have a special burden to overcome. To prevail, the plaintiff must disentangle race from politics by proving the former drove a district's lines. That means, among other things, ruling out the competing explanation that political considerations dominated the efforts. If either politics or race could explain the contours, the plaintiff has not cleared its bar. Easley versus Cromartie is another big, guys, these are big cases. I remember, I took con law in college and we went through Cromartie on these. There are a lot. There are a lot of cases. Sean, stop sounding like Russell. I'm trying not to. They say a plaintiff may carry its disentanglement burden by offering an alternative map that achieves all the state's objectives, including partisan advantage and any of the state's other political goals, at least as well as the state's map. That's a really high burden, chat. That is a really high burden. You have to achieve the same thing Louisiana wanted to do without, oh my God, I don't know how the fuck you do that. Ugh. I guess you can't. Sorry. Today, Section 2 litigants almost always have the wherewithal to proffer such a map. There's one to be found. And they go on here and they point out, there's always computer technology, too. But if a plaintiff cannot disentangle race from the state's race-neutral considerations, including politics, then Section 2 cannot impose liability. In short, Section 2 imposes liability only when the evidence supports a strong inference the state intentionally drew the districts to afford minority voters less opportunity because of their race. Nope, it's because you're Democrats. Black folk, come vote Republican. You do whatever the fuck you want. This interpretation does not require abandonment of the Gingles framework. We only need to update the framework so it aligns with the statutory text and reflects important developments that we cited Gingles 40 years ago. Four vast historical developments are a particular note. First, vast social changes occurred throughout the country, particularly in the South, where many Section 2 suits arise. This court has recognized things have changed dramatically in the decades since the passage of the VRA. This is Shelby County versus Holder. That's I believe that's Memphis. But yes, Eric Holder and the VRA, they were enforcing things. At the time of the passage, the nation had faced nearly a century of entrenched racial discrimination from an insidious and pervasive evil which had been perpetuated in certain parts of our country throughout unremitting and ingenious defiance of the Constitution. But the Voting Rights Act led to great strides in ensuring decades. The ensuring decades voting tests were abolished, disparities and registration and turnout were erased, and African Americans attained political office and record numbers. Yep. You let too many black folk get elected. You let Barack Obama get elected, Democrats. You played yourselves. By 2004, the racial gap in voter registration and turnout had largely disappeared, with minorities registering and voting at levels sometimes surpassing white folk. Black voters now participate in elections at similar rates, even turning out at higher rates than white voters in two of the 5 most recent presidential elections nationwide and in Louisiana. Second, a full-blown two-party system has emerged in the states where Section 2 suits are most common. Gingles arose in the context of a one-party system in which black and white voters had starkly different voting patterns, despite their affiliations within the same party. In the area involved in Gingles, an overwhelming majority of white voters did not vote for any black candidates in the Democratic Party primary elections, also known as white primaries, for which all practical purposes selected the candidates who would ultimately run for office. And in general elections, white voters in heavily Democratic areas often ranked black candidates last among Democrats. Shelby's in Alabama? Okay. I think there's a Shelby County in Tennessee as well. I think there's multiple Shelby counties. Such intra-party disparity showed that black voters had less opportunity to elect their preferred candidates because of their race, not because of their partisan affiliation. And they say, though, when the vast majority, regardless of race, favor the same political party, a map that is disadvantageous for members of one racial group can't be explained on the ground that it was drawn in favor of a particular party. But in a state where both parties have substantial support, and where race is often correlated with party preference, a litigant can easily exploit Section 2 for partisan purposes by repackaging gerrymandering as racial gerrymandering. Yep, this is the abuse. This is how you abuse the system. And they see it now, chat, and they're like, we're on to you. Uh-oh, guys. I don't like where this... If you're a Democrat, I don't like where this is going. They say that brings us to the third significant post-Gingles development, and that's in Rucho. They say in that decision, we held claims of partisan gerrymandering are not justiciable. Federal court, meaning the court cannot hear them. The upshot of Rucho was that as far as federal law is concerned, a state legislator may use partisan gerrymandering as a factor, and litigants cannot circumvent that rule by dressing their political gerrymandering claims in racial garb. They can't make it trans, chat. It is what it is. And they move on here and they say that this would be a convenient way for future litigants to sidestep the holdings for gerrymandering claims that not being allowed in court. And they say the fourth significant development since Gingles is the increased use and capability of computers in drawing districts and creating illustrative maps. The modern computer technology at the ready, Section 2 plaintiffs invariably invoke the assistance of experts who can generate thousands or even millions of maps. And they do. In these cases, guys, if you've seen them, they come out with like a million fucking maps. They come out with a million fucking maps in these things. Yes, all the white Democrats need to stop running for office. I agree. Quit diluting the black vote, Democrats. Computer algorithms can easily control for partisan preferences and other things here. With the advent of such technology, if it is possible to identify an alternative that achieves things that a Section 2 plaintiff can easily do so. Yeah, you just run a bunch of variations. In light of these developments, it's appropriate to update the Gingles framework and realign it with the text of Section 2. This is the new law, chat, right here. Below the tear line, chat, is what we need. Yes, the illustrious racial gerrymandering map. The first Gingles precondition is that a community of minority voters must be sufficiently numerous and compact to constitute a majority in a reasonably configured district. That's the first precondition. To satisfy this precondition, many Section 2 plaintiffs simply provided illustrative maps with their desired number of majority-minority districts. Such maps are not alone sufficient. They prove only that the state could create a map, not that the state's failure to do so violated the VRA. To make the latter showing, the maps must satisfy two conditions. First, plaintiffs cannot use race as a districting criterion. If the plaintiff can reduce additional majority-minority districts only by using race, a process that will be unconstitutional if the state engaged in that map making. That map sheds no light on whether the state acted unconstitutionally by not adopting such a map. That map, where race is used, has no value in proving the case. So, no maps like that. Second, the illustrative maps must meet all the state's legitimate district objectives, including traditional districting criteria and the state's specified political goals. If the state aims include a target partisan distribution of voters, a specific margin of victory for certain incumbents or any other goal not prohibited, the plaintiff's maps must achieve these goals just as well. So they're like, we want to be like R plus 15 in every district. And they say that out loud. The Democrats challenging it are going to have to offer a map that's pretty fucking close in every district. That's going to be tough. If the Republican legislators are smart, they can make almost impossible fucking burdens to be met. God damn. They can do a lot here, guys. They can do a lot. I'm just going to speak on the record. If not, the plaintiffs failed to demonstrate the state's chosen map was driven by racial considerations. This is only by meeting all the state's legitimate objectives can the illustrated map help to disentangle race from politics. So without it, the map has to do the same thing, just a different way. Woo! Chat. Whoa. Bald Eagle says, what are the ruling on this? 6-3, chat. 6-3. You can tell who is the 3. The second and third Gingles preconditions. To satisfy the second and third, the politically cohesive voting by majority and racial block voting by the majority, the plaintiffs must provide an analysis that controls for party affiliation. In other words, they must show that voters engage in racial block voting that cannot be explained by partisan affiliation. This is once again critical for disentangling race. And he's going to explain it with the facts of Gingles. Gingles affords a good example of how this is done. There, as discussed, black and white voters had dramatically different voting patterns within the Democratic Party. This type of intra-party racial block voting pattern helps to demonstrate the minority plaintiffs have less opportunity than their majority counterparts. By contrast, simply pointing to inter-party racial polarization proves nothing because a jurisdiction may engage in constitutional gerrymandering, even if it happens so the most loyal Democrats happen to be black voters, and even if the state were conscious of that fact. Yeah, it's like, sorry, too bad. Oh, they're all black. We know. Suffer. So there you go, chat. It doesn't matter. It's not going to matter. And the totality of circumstances. Lastly, this must focus on evidence that has more than a remote bearing on what the 15th Amendment prohibits. Present-day intentional racial discrimination. Discrimination that occurred some time ago, as well as present-day disparities that are characterized as ongoing, effects of societal discrimination are entitled to much less weight. Far more germane are current data and current political conditions. They say in a large part because of VRA, our nation has made great strides in eliminating racial discrimination in voting. As a result of this progress, it is hard to find pertinent evidence relating to intentional present-day voting discrimination that is cause for celebration. Yes, they're saying, listen, we're mission accomplished. Why aren't you guys happy? Shouldn't we be happy there's less discrimination out there? But it's just like the SPLC. With less discrimination, this law has less need. And with that less need, it's less effective and it's less it can be abused. And they point out ultimately here, nothing in Allen, and that's Allegan versus Milligan, dictates a result that differs from the one we reached today. The decision in that case was based on the state of Alabama's specific argument that its race-neutral benchmark was necessary in any redistricting case. And they say Alabama argued that deriving this benchmark, the median or average number of majority-minority districts in a race-blind multi-million map set require computer simulations that are technically complicated, expensive to produce, and available only to a smaller cadre of university researchers and the resources to run them. Nonetheless, the state continued its race-neutral benchmark was the only plausible test to ensure Section 2 stays within the constitutional guardrails. And they're saying, we rejected that single-minded view. And they say in Allen, and Bama Law, I saw you talking about this, in short, was about whether Alabama's novel evidentiary standard required a change of our existing precedent. It did not. They say Allen did not address the central issue here. We had no occasion, Allen, to confront the presumption that it compliance with Section 2 may serve as a compelling interest for a state to satisfy strict scrutiny. And then say, ultimately, they get through all this, guys. They keep going here. And what do we want to get to? What's the ultimate point here? And they say Louisiana's enactment of the map triggered strict scrutiny because the state's underlying goal was racial. The state never hit the ball, almost like it intentionally did this. It was a setup. It was a setup, chat. A complete setup. It configured District 6 to achieve a black voting age population over 50% because it knew that if it failed to do so, the Robinson court would likely find its map unlawful and release to something like the Robinson plaintiffs' illustrative maps, which would have imperiled one of the most influential incumbents in the legislature. The state's intentional compliance with the court's demands constitute an express acknowledgement that race played a role in the drawing of district lines. So once again, Chad, if you don't know who to blame if you are in if you're on the left and you want to know who to blame the people who filed this lawsuit, the initial one, because this is what they started. They stoked the fire raw instead of fucking consumed them. Consumed by the fires they stoked. And they say Louisiana had to satisfy the extraordinarily onerous standard of proving that its use of race was narrowly tailored to further a compelling governmental interest. And they say there's no compelling interest. Section 2 does not provide a compelling interest because the state did not need to create a new district to comply with the act. That is because at every step of the framework, the Robinson plaintiffs failed to prove their case. On the first condition, the plaintiffs did not meet their burden because they did not provide a map that met all the state's non-racial goals. The most obvious deficit in the plaintiffs' maps was the failure to meet the state's goals, including incumbency protection. The plaintiff's preferred map would have placed Representative Letlow in a majority Democrat district and effectively ensured her exit from Congress. The Robinson court erroneously concluded that the plaintiff's illustrative maps protected incumbents because the maps left all 6 representatives in the district where they currently live and could avoid incumbent pairing. And they point out this misses the point. An incumbent is not protected if he or she will lose re-election. And because plaintiffs' maps failed to protect all the incumbents the state sought to shield, the plaintiffs did not meet their burden. Whoa, chat. This is good. Nor did the plaintiffs meet their burden on the second and third. To show polarized voting, the Robinson plaintiffs offered evidence that black and white voters consistently supported different candidates. But their analysis did not control for partisan preferences. And there's a lot of white people who vote Democrat. Even if they had met their burden, they would still have failed to show an objective likelihood of intentional discrimination on the totality of circumstances. It says the Robinson court went through 9 Senate report factors, but none of the evidence it cited showed even a plausible likelihood of intentional discrimination. Much of the cited evidence, such as the low number of black Louisianans who have been elected to Congress in recent decades, failed to disentangle race from politics. Indeed, the court observed that black voters have been aligned with the Democratic Party for decades, and that issues discussed by that party appeal to black voters. Those observations should have undercut, not strengthened, any showing of intentional racial discrimination because race and politics are so intertwined. Robinson also relied on the sordid history of discrimination by Louisiana officials in the decades before the VRA, and it casts aside irrelevant the lack of evidence that black voters had faced intentional discrimination in recent years. Isn't that insane? Think about that. Hey, Judge, everything's actually going well. No, it doesn't matter. The blackies can't vote. The poor blackies can't do what they need. Give them more stuff. They're too retarded to get voter ID. You're like, whoa, buddy. Apparently, chat, that's okay. That's okay. That analysis had its priorities backwards. The 15th Amendment, which the Voting Rights Act enforces, is not designed to punish for the past, but works to ensure a better future. The focus of Section 2 must therefore be on current conditions, not on decades-old data relevant to decades-old problems. And none of the historical evidence presented came close to showing an objective likelihood the state's challenge map was a result of intentional racial discrimination. This is just a complete destruction of the state's argument, chat. Whoa. Wow. In some, because the VRA did not require Louisiana to clear additional majority minority district, no compelling interest justified the state's use of race in creating it. That map is unconstitutional, and its use would violate plaintiffs' constitutional rights. And notice here, he goes into this. The dissent's arguments are fully addressed in the prior sections of this opinion. But in closing, we emphasize 3 points. Sammy Alito is like, listen here, you dumb bitches. I'm going to break it down for you right now. That's what he's doing. He's like, listen, Ketanji, Sonia, and Elena. He grabs his cock and pulls it out of his pants, and he's just like this to their face. Just right up against their cheek. He's like, I'm going to break it down for you, girl. Here we go. Jefferson Post says, we met Sandra Day O'Connor's goal, chat. Oh. Bald Eagle says, how much are we going to bet the California Supreme Court upholds their new map that will now have major urban areas stretch across the state to get rid of Republican districts there? Well, it was already going to do it. It was already going to do it. Like, let's not act like that wasn't going to happen. But there are some things in play, chat, that the right can do more. The right controls more legislators than the left. So don't let, I hate to say, quote Sean Hannity, but let not your heart be troubled. You got to have some faith. First, the dissent states over and over again that our decision requires a Section 2 plaintiff to prove discriminatory intent. What must be shown is exactly what the 1982 amendment called for. A plaintiff in a vote dilution case must show that a districting scheme denies members of the racial group the same opportunity as other voters to elect candidates they prefer. When that is shown, the circumstances are comparable to those in white. The decision from which the new language added by Congress in 1982 is drawn. That is, the circumstances must give rise to a strong inference of racial discrimination. Second, contrary to the dissent's assertion, we have not overruled Allen. Allen is as is our general practice. The Allen court adjudicated the case based on the party's arguments, and in that case, the state did not defend its map on the grounds that it was drawn to achieve a political objective. Here, the state has been forthright from the beginning that its aim is to protect the state's most prominent Republican House members. Only one may lament partisan gerrymandering, but for reasons explained in Rucho, partisan gerrymandering claims are not justiciable in federal court. In racial gerrymandering cases like the one before us, race and politics must be disentangled, as even the author of the dissent has acknowledged. And they cite cases here, Alexander and Cooper, the opinion for the court by Elena Kagan, holding that a racial, notice, he's saying, bitch, I'm going to feed you your fucking, I'm feeding you your shit now, Elena. Open wide. Here comes Sammy. Holding that racial gerrymandering for plaintiffs must disentangle race from politics and prove the former drove a district's lines. That is true regardless whether the case is brought pursuant to the VRA, the 14th Amendment. And they say that since Section 2 of the VRA requires evidence giving rise to a strong inference of intentional discrimination. If race and politics are not disentangled and a Section 2 claim is cynically used as a tool, the VRA's noble goal will be perverted. Yes, eat it, Elena. Suffer, Elena. Suffer, Elena Kagan, you Kevin James impersonator. Third, while the dissent wraps itself in the mantle of stare decisis, which, chat, once again, is not a suicide pact, the dissent is unabashedly at war with key precedents. You know, and they're claiming that Rucho was disastrously wrong and should be cabined. You know, repeatedly criticizing Shelby County and citing the dissent in that case. Criticizing the court's decision in Brinovich. And it says, respect for precedent cannot be a one-way street. The district court is confirmed, and these cases are remanded for proceedings consistent with this opinion. What does that mean? Opinion of the court. It is so ordered. Total voter victory. Monster kill. I wish I had like the echo I could put on here because I'd be like, dominating. So guys, remember it's 6-3. Now let's get to, we're not going to go through all of this here, the complaining, but we are going to, there is a concurrence. And Clarence Thomas says, I join in full. And also Justice Gorsuch is like, Clarence, I got you back. He says, this court should never have interpreted Section 2 of the VRA to effectively give racial groups an entitlement to roughly proportional representation. By doing so, the court-led legislators and courts to systemically divide the country into electoral districts along racial lines. And then, yes, blacks were drawn into black districts and given black representatives. Hispanics were drawn to Hispanic districts and given Hispanic representatives, and so on and so on. Today's decision should largely put an end to this disastrous misadventure in voting rights jurisprudence. And he says, as I explained more than 30 years ago, I would go further. And this is where Clarence Thomas is like, remember, chat, there's always been a meme for a long time. Clarence Thomas was like, yes, I concur. And I would have said, fuck this law entirely. Or I would have abolished this principle completely. I will go further and hold that Section 2 of the VRA Act does not regulate districting at all. The relevant text prohibits states from imposing and applying voting qualifications in a manner that results in a denial or abridgment of the right to vote. How states draw redistricting lines does not fall within any of those categories. Clarence Thomas would be like, I don't care what you do. As long as you get the vote, that's all that fucking matters. Are you allowed to vote? Yes. Is anybody attacking you or stopping you? No. Then I don't care. And you're like, that's a pretty base interpretation. And I kind of like that one. Clarence Thomas is like, fuck y'all nibbas. I mean, it's very based. It's very based. It's super mega based. Clarence Thomas is just like, there's no way to answer him other than,
was this story based? Yes.
Absolutely based. Absolutely based. And he says the words in Section 2 instead reach only enactments that regulate citizens' access to the ballot or the process for counting a ballot. They don't include districting schemes over one another. Therefore, no Section 2 challenge to districting should ever succeed. Notice, chat, we have two of them here. Thomas and Gorsuch. Gorsuch is, if he was not in this, he would write his own concurrence. But we have two justices who are like, fuck this whole thing. That's impressive. And Gorsuch is going to be here for a while. Alito isn't quitting, and it sounds like Thomas isn't quitting either. So we get President J.D. Vance, so we can keep the House in 2028. Woo, buddy! We're gonna be doing. There's gonna be some legal ass fucking tonight. Let me tell you what. Especially with Sonia. Sotomayor got that sugarfoot. Oh, she having a rough time out there, chat. She having a rough time. Notice how short this is. Clarence Thomas is like, I'd fucking nuke this bitch. 2 pages. This is classic Clarence Thomas right here. Just yes. The correct application of language statute. I agree, MG Law. It's 100% correct. MG Law, how you doing, man? Hope you're doing well. Friend of the show out there, guys, locking it down out in the state of Oklahoma. Pretty sure it's still Oklahoma. So how you doing, buddy? Hope you're doing well. Mad Martian says legal ass fucking. Oh my. Yes. Just like that. That's what Clarence's dick would look like going in these people. Titty fucking those legal ass cheeks. That's right, Garrett. As we learned from that case in Florida, titty fucking them ass cheeks. Just bite through your lip. You bite your lip so hard, you just gotta bite through it. Oh. So what do we get to here? Justice Kagan, with whom Justice Sotomayor and Jackson joined dissenting. Notice, chat, we don't individually get We don't eventually get them going.
It just don't make no sense.
Yeah, notice we're on page 45 of 92. This is 45 pages of no, our poor black votes. No, you're hurting us. Stop. No. Oh my God. We're going to lose every election going forward. Holy fuck. Ah! That's what this is. Ah! And we get to the end. Ah, splat. I dissent because the court's decision will set back foundational rights Congress granted of racial equality and electoral opportunity. I dissent. That's a lot of coping and seething. Rip headphones. I'm sorry. Shino Booba says, can I have this on Spotify? I don't know. Oh. But here we go, chat. Here we go. So this ruling allows states to draw the maps for midterms. We're actually going to get to that because, believe it or not, chat, there is some movement here that, oh no, oh man, oh we need to zoom in on this. Chat, here we go. I got some news for you. And it's not that you're gay, but here we go. Bald Eagle. Get you. If you want to start rubbing your woody right now, go ahead and start rubbing your woody. The judgment is affirmed, the case remanded. We just read that. Okay. What happened today? Application for issuance of a copy of the opinion and certified of the judgment forthwith submitted to Justice Alito. Well, what is this, chat? Oh no. They're asking for something. What are they asking for? So it's and on an appeal, what are they asking for? An issuance of the copy of the opinion and a certified copy of the judgment. What does this allow you to do? So here's their concern. They talk about all the issues here. They say that ultimately the concern here is, here we go. The clerk of the court will not direct a copy of the opinion and certified copy for at least 32 days after entry, unless the court shortens the time frame. 32 days can matter. Under Act 640 of the 2024 regular legislative session of the Louisiana Legislature, the congressional party primary will be held on May 16th. The second party primary between the top two candidates from the first primary, if nobody wins an absolute majority, will be held on June 27th. However, it's appellee's understanding that the legislature is considering pushing back these deadlines to allow for the elections occur under a remedial map. Oh, wow. Wow. We'd like to do it now. We're going to do it live, chat. We're doing it live. Even if the primary elections are pushed back and the legislature moves the election back as far as November 2026, a return to the primary system, time is still of the essence. Because it is for the district court to either draw an interim remedial map or approve a legislative remedy, which if the district court drags its feet, there will be mandamus writs sought. Jurisdiction will be returned as soon as possible so it can oversee an orderly process. This would include the state of Louisiana, the Louisiana Secretary of State, and another set of interveners are heard. A delay of 32 days will endanger the process. They say that finally the relief will not prejudice the appellants because there's nowhere to go. None have indicated a basis for seeking a renewed consideration from the court, which at this stage is highly disfavored. You don't usually get rehearings or reconsideration. Weighing in favor of this request are the interest of judicial economy and limiting litigation cost, and the vindicating of the long unfulfilled rights of the appellees, along with the thousands of Louisiana voters who have suffered through one racially gerrymandered election and face a looming prospect of another in 2026. They don't want to vote for no black people down there. They want to vote for white folk. That's what they're saying. We ain't putting up with this shit anymore. So we want you to speed track this shit. We want you to speed track this, buddy. You know, and then they're looking at Alito and they're just telling him right now.
Licking their pencils right now, trying to write fierce as they can. Get every word of this here. Get every word of this.
Yes, chat. Oh, wow. So what did Sammy Alito do? Oh, we're going to find out tomorrow what happens. Response to the application is due by 4 p.m. tomorrow. Oh, buddy. Woo! Woo! And I know you guys don't like Amy Coney Barrett, Brett Kavanaugh, and I know Gorsuch is more based at times, but still. Remember, chat.
God bless you, Donald Trump. Keep the simplified fags out of our government.
Very true, chat. Very true tonight. Very true tonight. Yes. So we're not gonna take it is the anthem of the oppressed racial gerrymandering. Yes. Whoa, man. Ah. I am disappointed in Amy Coney Barrett. I am, but for right now, yes. Yes, Amy Coney Barrett is a New Orleans native. This was her home district, technically. Yes. Yeah, she's from New Orleans, and it ain't, there you go. So what does this mean? Well, I like, there are a couple people I follow on Twitter, chat. This guy, Christian Hines, he says, all Patriots go! Activation word, Ronald McDonald. Here we go. Mississippi going red. Louisiana going red. We're redrawing the districts, chat. Tennessee going red. And I know, Bama, you're saying Alabama can't, but if the DOJ's in charge of Milligan, they could say we're not doing it. And I'm sure the Supreme Court would probably, that might change. But yes. Ooh-wee, chat. Ooh-wee. Ooh-wee. And here's the big thing you guys need to understand. What this means, chat. What this means, buddy. Oh, God, you gotta love it. As the song goes, man, you're gonna like it because the hood gonna love it. You're gonna like it because the hood gonna love it. Oh! Possible redistricting scenarios. I like Shia LaBeouf and Fury when he blows up that one nest of guys in the ground. Yes. Yes, and here's the thing, Tejas. You are correct. Florida. Yes, my new home state. My old Florida home. Oh my God, chat. They are Ronnie DeSantis. Now I know, my parents love Ron DeSantis. He, I asked my mom and dad before, well, hey, what about President DeSantis? My dad's like, he's our fucking governor. Keep your hands off of him. I understand why, chat. I understand why. Because see this map of Florida down here? It got even more base than that, chat. The new Florida map. Oh, this is what came through Florida right now. Ah! Ah! Oh. Wait, can you say the N-word legally now? No, you can't. Oh my God, I need that Bo Burnham laugh clip. I need the Bo Burnham laugh. Make Miami Republican. Oh, it's going to happen. Don't worry. Oh my God, chat. It's so good. It is so good. It's so good. Oh. Here you go, chat. This is all I have to say in response. Chat. Oh God. Well, there you go, chat. There you go. We did it, chat. We saved the blacks. Yes. We saved the blacks. We did it. Here's what's going to happen, though. I mean, we're seeing this shit on Twitter now, where the fucking douchebags out there on the left are like, oh, look, we'll racially gerrymander Illinois. What do you think about that, Chuds? I mean, like, you guys already do that. Like, Illinois has already been racially gerrymandered. I mean, this is the map of Illinois. Like, it's already been gerrymandered a bunch. I mean, look at Illinois. There are only a handful of Republican candidates in a state like this. So, yeah, you guys have already done that. This is the map right now. And there's only like 2 Republican congressional candidates at all in Illinois. So, yeah. The blue states have pretty much been gerrymandered as much as they can already. Yeah, like they've already fucked this as hard as they can. I mean, if they really think like this is the own, it's like, I guess go for it, but, you know, just admit you're desperate right now. That's, you know, and like when you look at the Northeast, they're like Massachusetts, 40% Republican. They ain't got no seats. Like the entire Northeast is blue. Blah. It's blah. Like what about that? What about that? I don't know, chat. I don't know. So, but there you go. There you go. The purple is one state on that second map. Yeah, this is the state. This is what the Democrats are trying to argue they could gerrymander Illinois with right now. This is what their argument is that they could do spud gun. Yes, this is their idea of making the congressional districts. Because in Illinois, Chicago, über alles. And the joke, like in Illinois, the idea is, do you live north of Interstate 80 or south of it? But the current map of Illinois is this. And you notice, look how many districts there are in Chicago. Look at all those districts. And then you have this one here that runs all the way through the state. You have this one, which is like button hooked around. That's one whole politician. Has like half the state. And then you have these really obnoxious ones. So Connecticut is wild, but makes it look semi-decent. Yeah. Yeah. Illinois is a complete disaster. And the funny thing is, when you go back through time, you know what Illinois' congressional map looked like in 1992? This is right now. This is 1992. And look at it. You're like, okay, this seems kind of reasonable. Right? Okay. Even in 1994. It was gerrymandered again. Okay, still kind of reasonable. Look what happened. Look what happened to our boy. Yes, Cook County is the key to the Midwest. Yes. And from there, guys, it got out of control. It got out of control. And here is actually a better map of Illinois. Here is the better map of Illinois. Here's the better map of Illinois. Look, you can look at all these districts right here. You have like 3, 4, 5, 6, 7, 8, 9, and 10. All right there in Chicago. So you're like, well, how do these all break down? Well, let's look at the congressional delegations. Oh, district number 1. Look at that. A Democrat in Chicago. District number 2. Oh, a Democrat. Wow. District number 3. Another Democrat. Wow. District number 4. Chuy Garcia. Is it Chuy or Huy Garcia? Oh, wow. Another Democrat. Mike Quigley. He probably is a faggot. Number 5. Another Democrat. Sean Casten from Downers. He looks like he's the leader of Downers Grove. Another Democrat. Danny Davis, another Democrat. Raja Krishnamurthy, yes, sir, another Democrat. Jan Schakowsky, another Democrat. Brad Schneider, another Democrat. Bill Foster, another Democrat. Oh, and look at what? Well, we got one guy, a Republican. Look at his thing. It's like half the fucking state. It's like half the state. Wow, that seems fair. Nikki Baczynski, another Democrat. Lauren Underwood, another Democrat. Mary Miller. Oh, look, she's got the other one of these butt-fuck districts. That's like half the state. Two representatives for half the district. Wow, this seems fair. We have Darren LaHood. He's got another goofy-looking district that's been chewed apart. And then we have Eric Sorensen, which has the final one. Wow, look at that. 3 of them. Wow. Oh, yeah. We're going to fuck you guys even harder. You're already fucking us pretty hard here, homie. You're already fucking us pretty hard. You're already doing that. Like, I don't know what you think you're doing here. So, this is, it's just horseshit. It's just horseshit what they do. And, oh, actually, hold on. I want to see something here, chat. Hold on. The 13th district is that crooked one. The 13th district. Yeah, this fucking abortion one. That's another Democrat. Wow, look at that. That's totally like, oh, you're getting in Springfield and in Champaign-Urbana and Decatur. Wow, you're totally not just corralling all the black votes. Wow. Wow. It's totally not horseshit here, huh, chat? It's totally not horseshit here, is it? Yeah. So. So there you go. It should show up now, you guys. You should see it. Give it a second. Give it a second. Give it a second. Mike Middleton, good to see you, man. It says, right now, Tim Pool is having the biggest conservative boner to end all boners about this ruling. I mean, it's big. But let's be real, chat. What's coming that hasn't been decided, the citizenship thing? As I said, that's going to go down in flames. If that comes out, I'll have a fucking I'll have a Woody. I'll pull a Dark Side Fell and beat off on screen. I'll be staring at you as I do it. I'll be staring at you just, just the whole time in there. You'll just hear it. I'll just be staring at you like just grunt as it happens. It's not going to happen, though. It's not going to happen, though. EDW says, this is our siege of Callais, and we're getting waterfront property on the English Channel. Yes. Oh, Johan Naxos says, but Sean, how is this Rico? It's never Rico. The TRH51 or the Tura 51. Thank you for being here. For $5 says, the Raven White Tee from the T-Man at thedragonstreasure.com is one of my new goated tees. That's right, chat. Remember, promo code criminal, 10% off at the Dragon's Treasure. Thumb Ugly says, Dragon's Treasure, Sebastian's Morning Earl Grey. And Earl Grey is a type of tea, chat. Is a wonderful tea. I've introduced a few clients to Sean's channel this week as well. Cheers. 07s. That's fucking 7s in the chat. Thank you, guys. Remember, promo code criminal for 10% off. Don't cope. Who would proudly cope? Nobody would. You have respect for yourself. Don't cope. Zero Fuck says, what they lack in height, they make up for in width. Yes, the basketball players. Good to see you, man. Hope you're doing well. I did talk with Ryan Mullally. I was like talking to him today. I'm like, dude, like I was in the middle of something and I came out and it was done. And I'm like, dude, this happened. And he's like, I'm traveling. And I'm like, I can't wait. But I think we'll go over the TPS decision because that's hilarious. Apparently, Sammy Alito went wild today and was just giving it to the fucking immigrant population today. So, Bama Law says Alabama's still in court orders in Milligan until 2030. Ain't nothing changing. It's still nothing o'clock. I don't know. I feel like there might be ways around that. There's got to be a way. Maverick Cuba 1309 for $5. Thank you for being here, man. I appreciate it. Look like a new face. Thank you. When are we getting that American History X movie review? Invite Nate and bring in Joe for the one scene where we need him for. Not welcome. Yes, you see this? It says not welcome. Oh, jeez, chat. Jefferson Post says, we expect that 25 years from now, the use of racial preferences will no longer be necessary to further the interest, but not just for schools. Yes, very true. Thank you, Jefferson. The Razor's Edge, who's been a member for 4 months, says Ryan Mullally is mad when I said Amy Coney Barrett was a Trump mistake. I mean, I'm not thrilled with her, but she's done enough that I'm like, okay, it wasn't a complete bust. She didn't pull a fucking David Souter and just like flip the script completely. When he got appointed and nominated, he's like, fuck y'all, I'm a Democrat now. We're like, what? He's like, suckers. And we're like, what the fuck? So, yeah, luckily that's not us. That's not us. But yes, thank you for being here for 4 months, Razor's Edge. Thank you. Johan says, now repeal the 19th and it's all red all the time. Well, that would be true. Bald Eagle, 1787 for $10. Thank you. Says, I kind of want the GOP to bring suit against Texas, saying the districts around Houston, Dallas, and Southern Texas are race-based, which they are. I want to see how many more seats they can squeeze out. Oh, I'm sure now this has happened, I guarantee you people are laying framework and everywhere is going to be attacked. I guarantee you they're going to attack even in California. All kinds of states, everywhere. Their blue districts suffer. It's going to be glorious. It's going to be glorious, chat. Let me tell you what, buddy. And honestly, you know, she's delivered on enough things that, like I said, God bless Donald Trump at the end of the day. May he drink the adrenochrome of every Iranian woman and child. If that's what it takes to bring this a new age of American prosperity, to quote the great Dr. Steve Turley, then fuck yeah. Fuck yeah. Fucking A right, Bubba. To quote Gus Grissom. Malcolm Combs says, we have a similar joke about Seattle and Washington. Jefferson Post says, like they could use us massholes, they could hose us massholes any harder. Yeah, I agree. Amateur Iconoclast has been a member for 28 months. Thank you for being here, man. I appreciate it. Congratulations to you and EDW on your states being freed. May your state run red like blood in its redistricting chances. Bless you. Love you. Aw, she loves me. Off topic, could you teach Flash to see Iconoclast? I will work with him on that. I'll try. When he's not too busy dunking on EVS or the quartering, I will try to work with him on that. Objective Gestalt for $5 says, as an ATL resident, I'm curious to see how this is going to play out here. Well, hopefully you guys quit having faggy governors who they need to get a set of balls. And they want to crush the Democrats under their heel. Because remember, chat, the Democrats only understand one thing, and that is the boot heel. That is how they must be dealt with, is with the boot heel. You never let them up. So here we go. I'm ridiculous. Yes, it's going to play out. Well, I mean, hopefully your state is going to be based. Hopefully Ohio, even though it's going to be my sweet Ohio home. Hopefully it gets even more based. Hopefully Indiana gets even more based, and we just on everybody. Every state gets gerrymandered. I got hopes, Chad. I got hopes and dreams, and our legislators have the ways and means. So they're covering me on Keno Casino. Great. Oh, really? Hold on. Why did Indiana go full retard? Because they're cucked down there. They were just So, Indiana's going to pass it, the electoral votes in our lifetime. Yeah, well, I think at this point they realize they have to. I'm turning in Alex Jones. There's no shame in that. There's no shame in that. Honestly, I mean, here's the big point, though. No, the Pope has fucked that over, and the Pope is not my Pope. Not the first time I disagree with the Holy Father, so fuck him. Fuck him. What is my favorite water filter? I drink from the tap. I drink from the tap. Yep, Florida's gonna get. All right, so I can't get the Keno thing to pop up, so we'll go to the model stream or something. The casino's at 10.8 thousand viewers. Fucking respect to the boys over there, even though they're Canadians. God, they're trying. They're trying their hardest. Maybe one day Andy will get the race war that he so desired. Him and JF can lead the right wing death squads through Eastern Canada. Maybe they will. Maybe they will. One day, by God, they will have their home again. They will make Brampton fucking Indian free, maybe one day. U.S. Catholics have approved the Pope for a while, yes. The Pope is an instrument of godless devilry. Okay, what homo Protestant faith are you part of then? My Pope is John Paul II. This one, not so much, yes. Ohio's governor loves the Haitian TP. Yes. Yes, Mike DeWine. Remember, Mike DeWine was a guy who voted for the assault weapons ban in 1994. Mike DeWine's a fucking scumbag. I don't like him. I don't like him. So, Sean just runs the hose inside to drink. Well, I mean, yeah. So I was just viewed by 10.8 people. Yeah. Oh no, Sean is fluoridated Florida man. Of course I would be. Of course I would be. The first American Pope at Sean disavows. Well, if he wasn't a big faggot, I wouldn't disavow him. I'm sorry. Did you want me to be like, oh, no, look, he's a big old faggot, but USA, USA. No. Can't be gay. Can't be a big old bitch. No. 9. Nepa. Just saying, chat. I requested a bulk for Bad Jer's wife. Well, there you go. As said in Helsing Ultimate Abridged, fuck the new Pope. Yes. My Pope is St. Peter. Well, yes, he is the original. Last couple of popes were commies. Yes, that is true. He spent most of his life in Peru. Yes. What do you think of the new NFA rules? I mean, there's a couple of them that are kind of neat. I don't need approval. As long as that, because I'm moving, I need to get my NFA paperwork in order. And I kind of forgot about that till earlier this week. So hopefully this goes into effect soon enough. And they're just going to be like, don't worry about it. Just move and send it later. It's kind of what I'm hoping for. Because I really need that. I really, really do. So I don't have the time to get it done. And I don't want to leave my guns here and come get them. So, yeah. But overall, none of them are awesome. They're all kind of gay. They're all kind of gay, but we'll go over those tomorrow night. If you guys are new, we do our Thursday night show. Obviously on Thursday nights, tomorrow night. We got a lot to talk about. The guy in Florida who's talking about killing women got arrested. The Fauci indictment regarding FOIA abuse. James Comey got indicted once again. Chat, that is a snoozer. It's a garbage indictment. The Ninth Circuit allowed the DHS to use tear gas. We're going to cover this along with the ATF stuff. There's a couple of Second Amendment AI slop channels out there now. And it's funny because they're literally copying Armed Scholar. And it's hard to tell the difference in how gay they are. The Trump ballroom motion, and also the massive raids in Minnesota, where apparently we're now finding all the fraud that apparently wasn't there to start with. You're like, how does that work? How does that work, chat? I don't know. But it does, apparently. So we'll be doing that tomorrow night at 9:30. I wish PA would redistrict too. I'm very fickle at my pontiffs. Not really. They got to do the right way. Yes, why can't we have, yes. Why can't we have Pope Pius the 13th? I know. I'm not going to lie. His bait, the young Pope, that was a base show when he was getting the church to do. I was like, that's based if the Pope was like that. So, freely crossing state lines would be pretty tits. Yeah, it would. Also, just moving, and then it's like, yeah, file it sometime later. You don't have to have it done before you move. I know. I'll have to straighten that out regardless. I know, and that's my problem. And I was hoping that, it would be all done, and then I heard it, and I'm like, fuck. It's like, so I'm going to have to figure out what I'm going to do there. So, Ship is saying the Comey indictment will go to trial. It's probably not. Even if it does, he's getting acquitted. So, Ship is like huffing that hopium. If Fauci got pardoned, does he lose his Fifth Amendment right? Yes. He is no longer, if he's been immunized, it's basically immunity. Sir, you have to testify to what you saw. You can't be prosecuted. Yep. No, they did not raid Nick. Let's see what else we got here. About Jeremy, I'm thinking about the quartering. Could become liable for a lawsuit if he flags enough channels and causes enough damage to people's income. Would you do a video about that? I mean, I could do a video about it. Yeah, there's a lot of legal theories, but ultimately, here's the biggest thing. Are you going to get anywhere in court? And when you talk about damages, and this is like, and I'll do this, Troll Patrol. When it comes to this damages stuff, you need to think about like the Johnny Depp trial. Because unless you actively interfere with a contract, a lot of it's speculative. And in Johnny Depp was able to prove it, but Johnny Depp literally had $1 million experts. Johnny Depp hired a computer expert who modeled something, and they probably paid $500,000 for it. Johnny Depp also had an expert who was like the most Jewiest entertainment lawyer in Hollywood who had been doing it for like 50 years. He knew all the studio execs. He knew all the scuttlebutt. He knew everything about anything. He was like the Ace Rothstein of Hollywood. And he could say, I know this studio. And they all didn't hire Johnny Depp because of this, because I talked to all those people. And word was on the street and my ears to the ground. You need that kind of information. You're not going to get that with YouTube. Jeremy just being an insufferable faggot who should get hit by a bus. That's not enough. That's not enough. It's a legal case, yes. But will it get anywhere? I doubt it. Unless Jeremy's retarded enough to engage in things, but you're going to have to show damages. And that's going to be the toughest part. I'd be happy to do it, though. But I don't want to gas you guys up. And that's something, Troller, I don't know if you're new here or not. I don't try to lie to you guys. I don't. There's no point in that. If I tell you something's going to happen and it doesn't happen, I look like a fucking idiot. And even when I want stuff to happen, if it's not going to happen or it's not going to work, I'll tell you. Birthright citizenship. We're not going to win that. It's going to be 7-2 against. It's just the way it is. Getting machine guns legalized. The NFA fully repealed. Not happening. You would need 9 Clarence Thomases to make that happen. And even then, might not happen. So, I'm not going to lie to you guys on that. There's no point. I can't gas you people up. It's the reason why I don't have shitty clickbait everywhere. I can't do it. It makes me cringe. Adam says 7-2 no, 7-2 against. 7-2 upholding the 14th Amendment as currently viewed. Donald Trump's going to lose 7-2. He's going to get Gorsuch, or he's going to get Thomas, he's going to get Alito. Gorsuch is going to be like partially dissenting, but he won't dissent where it matters. So it's going to be like 7-2 with a partial dissent that's really irrelevant. So, yeah, thanks for answering. Of course, man. That's what we do. I do what I can, man. I do what I can. Like I said, I'd be happy to do something about it. And once I move down to Florida, because I'm not going to be practicing for a while, we're going to be doing a lot of videos. We're going to do a lot of day streams. We're going to trials, all kinds of fun shit. Just you watch. Maverick Cuba for $10 says, I was reading the bulletin board at my local bowling alley, when my bully stole my Red Bull and my wife. Now that's me in the corner, while my hot wife is in the back room losing her religion. Although it looks like she's probably praising Jesus, according to Jeremy. Don't use Jerry's idea of shorts. No, I won't. I won't. So. No, because I reject the concept of papal infallibility, because that's not a traditional concept. That's bullshit the church invented later. So there you go. You're not even good trolling anymore, Patty. So, all right, guys, that is it for us. That is it for us. We are What are the oranges for? To put them up your ass because you keep leaking too hard, Jeremy. Your butt plugs. They're like Benoit balls for his ass. Oh wait, Jeremy's gonna do that. He's probably like, "Oh, that's an idea, Sean. Thank you." So, Debbie O says, "I missed your super chat." Oh my gosh, I did, Debbie. I'm sorry. Oh, I did. I'm so sorry, Debbie. For $5, Debbie says, I don't recommend drinking Florida tap water. Not sure I heard that convo correctly, but just in case. Yes, I'm a big tap water aficionado. I mean, I drink where I live. I mean, really anywhere. Like all these suburbs and cities, they all use Cleveland water. I mean, I drink Lake Erie water all the time. And I've drank Lake Erie water on and off for, a good part of my 40 years being alive. So hasn't killed me yet. But thank you, Debbie. I will I'll work on getting a filter then. I'll work on using a filter. I'll try. Yeah, don't do it. I won't. Are we doing you're gonna do more. We got some time, chat. I got a little bit of time tonight, so we'll do a little bit of time. We'll do a short model stream. It's 10:30. We got some time. Keyword yet. Yes. I drink from the hose? Goddamn right I do. I ain't no bitch. Drink from the hose, be a man. So I remember Florida tap water being a kid and visiting grandma. It's like watered down water. Ew. Ew. So yeah, we are gonna do a model stream chat. We got some time. We're gonna do that. We're gonna hang out. I'm gonna put the casino on because I kind of want to hear some stuff, but also today was okay, but tomorrow's gonna be a long day. So I'm gonna need some relaxation here. So we're gonna do some more elephant building. I think we're getting to the point of like doing the formal paint job. We're just getting a lot of parts done. So we need to watch your part in the casino yet. Jeremy's getting big felted again. Yeah. The Florida tap water is almost a solid. Oh my god, you're scaring me. Debbie, ew. That's fucking nasty. That is so disgusting. What happened to you people down there? What are we gonna meme copium says what are Satsuma's for? Yes. I'm just surprised. I'm just surprised in that, Debbie. It's just so nasty. Like, ew. Ew, brother. What's that? Ew. Ew, brother. But it's like solid like that. It's near solid because of all the bath salts. Oh. Oh no. So the state is just a slab of chalk sitting on the ocean. Yeah. Ew. You need the reverse osmosis system. I assume we have one in the house we're getting. The house, the house we're looking at there. and chewing his water. But hey, maybe it'll help me like lose some calories. I'll get fuller. I'll get filled up. So Clyde is going to be gator bait. That is a big concern of us, me and 2.0, because Clyde, when he gets out, he likes to go adventuring. Thankfully, he's too big for eagles. But yeah, we could see him going up to a gator and like, "Hey, what's up? Would you like to play with me?" And the gator bites him on the head. And he's like, "Ow, ow!" Like it's a little scary. It's a little scary. So, Erica says I can hook you up with an awesome reverse osmosis system. I think we've got one. I don't know though. I don't know. I think we have one, chat. I don't know. I gotta look it. Let me look something up here. Let me see here. Let me see if this is the case. Oh, yeah. Let me see here. Is there? Where is? Yeah, it didn't work, chat. Mine. Hold on. Let me ask. All right, Erica 2.0 might be talking to you. So yeah. So well, anyway, you don't know if you have an RO system. If you do, who has been refilling the salt? I actually I forgot to check if this has it. I'm looking at the listing right now. Uh, I do not see it, chat. I do not see it listed on here, but that doesn't mean it's not there. Huh? It's a new house. It's a newer house. It should, I'm assuming. So yes, I get some water brand water. Debbie O says, I have a Blackstone sink in the kitchen. If I send you a photo of it and the residue of the water leaves, you won't be drinking the water. I take your word for it. That sounds disgusting. Oh, I'm not doxing myself, chat. Dox your mom. So, all right, chat. Well, with that said, we'll take this over to the model street. What's RO? Reverse osmosis. It's water filtration because some of this shit can get nasty if you're in bad areas. Yes, that move to Florida could be potentially criminal now. I may have to work on getting that sorted out here. I may have to leave it here and come back for it later. And I have places I have an FFL I can go to, so who will take care of it for me. So that's something I could totally do. Hold on, chat. Oh, there we go. Oh, no. I'm sorry, I was trying to click on the right thing here. Okay. So, but yeah, I have an SOT I can leave them with so they can take care of it. Joke's on you, everyone's docked with my mom. Well, there you go. Oh. But yeah, Tejas, you're correct. But like I said, I have an SOT I can hang out with, so he'll take care of me. So, but also technically, if I put a full upper on it, it's not actually an SBR anymore on those, so I can move SBRs. What's an SOT? An SOT is a special occupation tax. That is basically a gun store that has special permissions by paying more taxes. They can handle like they could buy and sell suppressors with them. Short barrel rifles, machine guns, they can also do and make those things. So not every gun store can do all that. You have to go to certain gun stores. It's called a Type 2 or Type 7 FFL is typically what they do. So with that said, though, chat, we're going to end here, and I will see you guys tomorrow. Remember, until next time, chat. Just because you did it does not mean you're guilty. And once again, God bless Samuel Alito. Good night, chat. Good night.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that